point that everybody is so anxiously awaiting. I wanted to say that, my hope today, and I don't know if I'll be successful or not, is, less education, more conversation, and maybe some inspiration and celebration, because the whole point of discussing juvenile defense representation, why we keep talking about it, is because it's hard. This is a difficult practice. There's a reason why some people start and then quit doing it, because it is a hard thing um, to think about, to implement and act on, when seemingly the rest of our universe in the four walls of that courtroom don't really know what we're doing or why. And so, this is a back to basics part of our series. Uh, but I know that a number of the people who were registered, we've got a range from people who have been practicing for 4 decades to people who have been practicing just in the last couple of years. And so I'm hoping that at some point in this discussion, folks will come on and talk about some of their experiences and just how they get through that day in court when seemingly, again, everybody is thinking something else and challenging basically the reason why we're here and why we're doing it. So with that, let me share the screen. Hopefully I can do this right. Okay, is that good, Yolanda? Okay. So as people who know me know that I can be a little irreverent sometimes. So when we talk about this, I started out thinking about it and saying, well, it's easy for us to say, your role at counsel is expressed interest advocacy. And yeah, there's a picture B on the screen. Sorry, you're seeing me twice. But I do this because I can only imagine how attorneys out in the field feel when, since 2005, we've been harping on this. If you've been practicing since then, this is kind of, our standard discussion. Why do we keep talking about this, and why are you keep discussing it? Well, like I said before, it's, in my opinion, less about, policing what people are doing and more about trying to support what you're doing. And this is what we're doing today. We're hoping to give you some, you know, dare I say it, philosophical tools so you can think about, you know, why you're doing what you're doing, how to do it, but also how to communicate to other people. Um, and I know that, we're here sitting in Raleigh, my swanky Raleigh office, as you can tell. I don't practice law anymore. Um, I'm a middle-aged dude, but we do have attorneys, two attorneys in our office who still practice, Terry Johnson in Iredell and Alexander counties, Berkshire Hensley and Wake County, and Yolanda just got out of the courtroom. We do have folks who are doing the work now. And so that really helps inform how we continue to think about this issue. It's not, there's words on the page, but it's not static. We continue to evolve in our representation. And I think that's important because, quite frankly, it gives me a reality check. Because, as Yolanda was saying, I haven't practiced in a courtroom since December of 2004. And so, it can get, um, very remote in how it really is to be a defender. Although I will say, and those of you who have read our blog know that I still go out. We all try to go out to court to make sure kind of we get a feel for what's going on. Of course, we always appreciate when folks call and talk to us about what we're doing. Not only so hopefully we can assist you, but we get a sense of what's going on the ground. And that's why I hope um, folks are willing to kind of chime in on this issue. Um, so why are we talking about this? Like what, you know, shouldn't we be able to read about this somewhere? Isn't there a YouTube video or what is it now? TikTok, is that what it's called? I'm kidding. I know what TikTok is. I've got two teenagers. Um, I mean, I think one of the reasons is seriously, how many of you in law school studied this? If you were not part of a clinic that focused on this, I'm guessing you didn't talk about now, you know, attorney A, B, and C. Now, when you go into juvenile court, here's your role. Okay, this wasn't discussed because guess what? You know, it probably wasn't discussed in your criminal law and criminal procedure class because everybody got it. You didn't have to discuss it. There was no thinking about it. But then suddenly, you know, you're dropped into this other world. Um, and again, it's a constant discussion because, you know, the law changes, the personnel in the court change, and not least of all, the law changes. We have seen in the past handful of years the two most impactful changes to our law and procedure. We raised the back age of delinquency, and then we just raised the minimum age. So our clients are shifting. And so we're constantly thinking about how do we best communicate with our clients and how do we best communicate with the other people we're working with. So when we have talked about this issue in the past, we go over the litany of the history of why we do what we do. Like what is the history of expressed interest advocacy? I'm going to bypass that for today. Um, there are other resources you can find this. I'm going to list those at the end. So we're not going to go into a long discussion about In re Galt and what it says or doesn't say about this. We're not going to talk about the history of the development of the role with, you know, national standards and how this kind of came about. Um, and even near and dear to my heart, I'm not talking about the statement of role of counsel that we developed near the end of the first year of our office that has been the underpinning of everything we do. Because, one, I'm going to make an assumption that maybe you know, but even if you don't, I want to talk about this more in real time and not about, you know, and our book doesn't say it, but not what's in the law or, you know, if I had the rules of professional conduct sitting next to me, I would pull them out. But I am going to pull them out in a second because that's, you know, what we do when we talk about ethics here in North Carolina. Okay. I am also, some people are going to shudder, not going to go into hypotheticals. There may be a war story or two. There's going to be a few reflections from me, but what we want is to hear from other people about how they see what they do and what they're experiencing. But I'm not going to throw something out there where everybody's got to take a few minutes and figure out like it's law, you know, law exam or whatever, the bar. We're not doing that. Although it'd be nice if the bar put this on their exam one day. Yes, I said that out loud. Okay. So I did want to mention that the rules of professional conduct, just in case you're wondering, don't talk about juvenile representation at all. They weren't written, nobody thought about this. But Rule 1.1, 1.2 especially, and then 1.14, if you need it, are out there, okay? 1.2 says, you know, you represent the interests of your client. It doesn't say unless you're in juvenile delinquency court and then you got to figure it out. That has never changed. Some people like to talk about Rule 1.14, and that's because it talks about the client's capacity diminished and specifically minority. Um, I'm going to be honest with you. This is one person's theory and opinion. To me, this is more capacity to proceed than like we represent a young person, or it may come up in another setting, but not in our setting. Our setting, Rule 1.12 still applies. We represent what our client is telling us to do. And we will discuss how that kind of works, but that is sort of the basic and bottom line. And like I said, I think and hope sort of everybody has a handle on that. So this is a little odd, but I am going to ask you, we're going to take 3 minutes, no more. And I want you to think about a couple things. One, when was a time that your role was challenged? Like an individual, an entity questioned why you did what you did. And then another time where your expressed interest advocacy was a success. We're going to return to this later on in the discussion, but let's just go to like 1:15. Just take a couple of minutes of uncomfortable silence in your own thoughts, write it down. I'm not going to call on people individually in case you're worried, but I might ask for volunteers. We do have a few plants in the audience, but I encourage everybody to speak up at the appropriate time. We will get to that. Okay, start writing now. Okay, just a few more seconds and we will be moving on with the program. Okay, pencils down. All right, we will come back to your thoughts later. Now, sometimes when we're in court, um, we think about things, maybe we do things, or we see things that make us think twice about what we just did. Um, I know that I have been there. I assume that others have been there, maybe not. And I just want to throw out kind of a few examples of where we get caught, preventing us kind of from doing our job as our client's voice to the court as expressed interest advocates. A lot of time, not a lot of times, you know, we have our clients, maybe we've represented our client more than once in court. We call these legacy clients. And we just get the sense that the court is like, okay, Mr. Zogry, I know who your client is. You don't have to talk about your client. Your client's been here many other times. Um, and so what we start doing is like reaching for positive things we can say about our clients. And what we end up doing is like apologizing. And it sounds something like this. Well, Your Honor, I know my client could do better. I know my client's been in front of the court 25 times. And I know my client um, doesn't get along uh, with his parents. And I know my client hasn't been to school. And I know my client hasn't failed the drug test. Does this sound familiar? And like you say all these things thinking that you're leading up to something. And at the end of it, it's like, but my client's a good kid, Your Honor. My client talks to me respectfully. Um, my client answers my questions when I ask, and look, my client is wearing a shirt today. I mean, I think sometimes we just get stuck do into this reel of just sort of apologizing instead of focusing on what's positive first and not worrying um about all of the negative things, because guess what, everybody else knows that, and it's pretty much everybody else's job to bring that up. We'll talk about roles of the other parties in a little while, but I don't know that that's something we have to do. Another thing that tends to happen when we're in court, and it's gotten worse because of these things, is we get distracted. Sometimes we get distracted because we just have too much going on in our professional life. Like we have to be in 6 courts at once, and you're already thinking about, okay, what am I going to say to the prosecutor in traffic court about my other client, and I need to be down at the jail, and I forgot to file something. I need to go file this, right? Um, and I think just like in real life, if you, with our own children, or if you've been with young people, they need extra attention, not only in your direct communication, um, but in the way you're presenting them to the court, um, and trying that much harder um, to speak with them, to talk about where they want to go with the case, and to articulate that in the court. And it takes more of an effort, but we just have a lot going on in our lives. But it's kind of something to think about. Something else, quite frankly, that I've observed in court is nothing. Uh, Mr. Zagrod, do you want to be heard on the facts? Nope. Mr. Zagrod, do you have anything to say about disposition? Nope. We agree with the recommendations. Okay, now maybe there's been a lot of like background discussion or communication, um, and you've worked something out, and you don't feel like it's necessary to say anything to the court. Um, but part of the problem I have with that is that your client sees this. And one of the reasons we're expressed interest advocates is to build credibility and confidence with our clients. And so I think it's always a good thing to just say something positive, to be talking with your client about kind of what's going on, um, and to present that to the court. Because again, unfortunately, it tends to be that other people want to say bad things about our client. And whether or not we notice it or our clients articulate it, they're looking to us to be their champion in that courtroom, in that situation. Again, sometimes it it's easy to forget that. And sometimes I describe it as, I think most of the people around our clients are talking at our clients, right? Whoever it is, they're not talking to them or having a conversation. They're telling them what's going to happen, and this is what's going to happen, and this is what's going to happen. And again, largely because it's that youth adult, right, kind of relationship. But our job is to listen, is to be honest with them and talk to them about their options, and to work with them to come up with a solution that they're driving, that we bring to the court. So I think standing there and not really saying anything can be harmful. Again, going back to, well, that's easy for you to say, Eric. You're sitting there in Raleigh and you don't have to do this anymore. Well, I understand that. And I can't imagine there's not somebody on this call, including myself, who hasn't at some point questioned what they were doing and why. Maybe it was with an individual case. Maybe it was just after a long week. Maybe it was after a long career. I don't know. Um, and so it's important, I think, that we reiterate to ourselves, like, okay, And you can talk to yourself in court. Nobody's going to think anything's weird about that. But you might want to go off to the restroom or while you're going to the vending machine to do this if you're going to talk to yourself out loud. But in all seriousness, I think we need to do this sometimes. And I think it's helpful. Um, let's go back and think about why we are doing this. I mean, number one, nobody else, believe it or not, nobody else is looking out for our clients' procedural and substantive rights. Um, my personal belief is that procedure is our client's friend because I think others feel like informality is the way to address, you know, youthful alleged criminal behavior. I don't agree with that. I think a lot of times that gets our client in trouble. And suddenly they're we put them in detention and now they're in there for a long time, or we're not actively trying to find the placement for them, or we're not trying to get the evaluation they need to move on with disposition. Um, but sometimes it's just the basics of, okay, well, I'm not going to waive that 10-day or 5-day or whatever it is. I'm not waiving. Okay, well, why aren't you doing that? Come on, it's easy. You know, it's for everybody else's convenience. Well, that's not my client's convenience, Your Honor. You know, and again, it does two things. One, it reinforces to the court there is a procedure here, and your client sees this. Instead of you wandering over and saying, I'm your expressed interest advocate, they see that, they understand that when you're up there saying, no, Your Honor, we object to the continuance. No, Your Honor, I'm not going to extend the 10-day secure custody hearing a couple more days. If we need to, let's come back to a different day in court. They see that, they understand that, internalize it, and it's important for us, to project that. If it ever gets down to it, I know I wasn't talking about golf, but you have a constitutional right to counsel, okay, beyond what even our statutes say. It's not something that you're making up in court, or you called OJD and they told you to do this. It's the law. It is the law of the land. I mean, quite frankly, it's why some of us became lawyers, because we wanted to protect, your rights under the Constitution. Hopefully, there's some heads nodding. I can't see. But yeah, right? I mean, we do this because this is what we're supposed to do. And I'm laughing a little bit, and I'm sure others are, but likely there is a procedure for this in juvenile court. Not always. I'm not saying it's always completely well defined, but you know, make sure you follow that. And maybe in some of the stories where we'll hear, somebody will talk about how, you know, um, holding the court to that procedure um, led to a positive outcome for your client. I mean, I hope some people are, I guess, saying, yeah, we've done that. And again, that's our role as expressed interest counsel. I'm getting on, I guess, a soapbox here. I get concerned sometimes when I hear or see people say that, well, we didn't actually follow the law there, but we got a good result. It's like, okay, um, are you sure? Like, if it was on appeal or something else happened, it wouldn't be challenged. Well, but that, um, and most importantly, what did your client think about that, right? Um, it's no wonder that if if families have not been in the court system, and their, understanding of the court system, maybe what they've seen demonstrated in the media, whether it's on, it's, you know, something made up, or it's something in real time, in real life. Um, they're confused about all this kind of milling around and, what are you doing? Who are you talking to? Why is this going on? And why aren't you doing something? Why are you just sort of sitting back and there could be reasons for that, right? And it's called practicing law for a reason, right? Because we all have different ways of doing it. But when things get so kind of sloppy, it's hard for us to get back on the cliff where when we're in the mudslide, say, okay, we need to get back here. Um, and I know from my part, I mean, I've been to some courts and observed the proceeding, and I was awake, folks. I didn't understand what was happening. I mean, I understood what they said, that where they started, like we're having a probation violation hearing or we're here on first appearance, and then it turns into something else, right? You know, and it's our job to like steer that back because it's going to end up probably harming our clients, right? Because the system wasn't made that, well, necessarily to be like that. So I just would sort of keep that in mind. Everybody who's practiced in court has seen this. That you have five kids on in court that day, and they're charged with different stuff, and they're adjudicated of different things, but yet they get the same disposition. Now, we have a juvenile court because the idea is that it's more individualized justice. That's the idea, at least. Why is everybody getting the same result? That shouldn't be what's going on. I mean, it should be individualized justice. And so, sometimes what we hear, and I'll get to this more in a second, is, well, my role on the front end is I really protect my client's rights. Then we get to disposition. I don't know. Maybe I'll say something, maybe I won't. Okay. So there's some switch that turns, or how do you explain that to your client? That you fought really hard, um, to get the charges reduced, or you tried the case and you lost, but now that we're at disposition, my hands are tied. I can't do anything. I don't think that's what our client expects, and that shouldn't be what happens. Um, so we need to fight against the the unnecessary regularity with which our clients are, you know, put on probation, or the length of probation, or the conditions of probation. Um, you know, I think this is sort of a dark corner of discussion, but I think we have all seen, observed this. Hopefully, it's not happened to us personally, but this court can get like this. That everybody's just kind of tired of, kids being charged with crimes. I mean, everybody has sort of seen, or it's been portrayed in the news media about the seriousness of offenses. So, we feel really burdened. Um, and then, like what I was talking about before, I mean, like the judge, you know, not the court is not really thinking about these cases individually, and it just seems like, well, it doesn't matter what I do. And we have to fight against that feeling that it does matter what you do. And that sort of lack of discretion combined with hopelessness, can be really, really difficult. And I know that. Again, I'm distant from the actual courtroom, but I know that it still goes on from talking with all of you about your cases, and talking, not just internally with Terry and Berja, but talking to folks out in the field. And I know that it's difficult. Again, I know I'm maybe harping on this a little too much, but The reason we don't have all these kids in adult criminal court is because in adult criminal court, generally, not always, but generally, what do? What's the mathematics going on here? What's the analysis? Well, what are you charged with, and what have you been convicted of in the past? And with that, we're going to go down a chart and figure out where you lie. Okay. Yes, we do have a dispositional chart in juvenile court, but that's really not, that's the start of the discussion, not the end of the discussion. All that does is show you, okay, what are available in these menus in level 1 and level 2. And even in level 3, when it's YDC, there's that part in the code that says you can suspend something. You don't have to go to YDC. There can be other ways of addressing the behavior. And that, I think, really falls on our shoulders. Now, I know you're going to say that, well, it's DJJ's job, right? I mean, DJJ is supposed to come up with the plan, but what did we just talk about, right? Boilerplated justice. I mean, is it really a plan? Or is this just kind of what came out? Because you plugged it into some sort of system and this is what it spit out. We should know more about our clients than anybody else in the court. And if we can bring something that the court can accept as to an alternative on the front end or the back end, I'm talking about both, we should do that. And that's why we're expressed interest advocates, because we're the agent of change, right? We're the ones to come in and say, this is a new client, this is a new day. Please treat the person I'm representing here as an individual and not run through whatever you did last time. And I have got some suggestions for you, Your Honor. All right. And you're still thinking to yourself, huh, that's easy for you to say, Eric. You never have to talk to anybody. You're sitting up there in Raleigh. No. Let's say we get ourselves oriented and everybody's cool with that. Like, I know what I'm doing and why. What's the problem? Problem is nobody else is either paying attention to what I'm saying or doing, or they don't agree with it or don't believe it. I was at a courtroom recently where I was talking to a non-defender stakeholder, and they had said to me, I said, well, how's it with the defense bar? And the person was saying, well, they asked for continuances. I said, well, why? Well, I guess they have to talk to their client about the case and decide what to do. Okay. What else? Well, a disposition, they keep giving us other options. Like their client doesn't need community service, or their client doesn't need to pay restitution. And I'm like, really? I mean, that's what I wanted to hear. But my point about saying that is, to them, that's not what they should have been doing. And they didn't even know that they were telling me something that was positive about the attorneys, because that's how they think about this, right? It's 2023, folks, and this is still going on. So why what do we say to other people? How do we express it? Like I mentioned before, as their lawyers, you know, we can talk to them all we want, but it's demonstrating what expressed interest advocacy means. And yes, I'm going to go into a few stories here, pardon me. Sometimes this involves shackling. Um, Everybody who loves the shackling rules in North Carolina, raise your hand. No, I'm kidding. We know that shackling is done differently everywhere around the state. Sometimes there's a hearing to remove shackling before the kid comes in. Sometimes they're sitting in the jury box with their shackles, and then you might unshackle them. Sometimes just their hands are unshackled, but not their legs. And I have seen this happen where they're having a shackling here, and the state says, well, Your Honor, the client's at flight risk. They have no evidence of this. And court goes to the attorney and says, Madam Attorney, do you have anything to say about this? No, Your Honor. We have nothing to say. Now, I don't know what that conversation has been. So there could be some reason for this, but this is what I see. I see the client looking at the attorney in disdain. Like, you couldn't even ask for this to be removed. Okay, that immediately, right? You're starting to break into, that relationship. So that's when you're telling it to whomever why you're doing this, because you need to strengthen the relationship. So there is a theory, but I think some of us have seen this, that if the youth believes that they are being treated fairly, but let's be more specific, that someone in the system is on their side and trying to ensure that the court is treating them fairly, guess what, folks? They're less likely to come back. Why do I have this sort of flea market thing? Well, I'll tell you a quick story. When I was practicing in Greensboro, I had a young man charged with larceny in an indoor flea market. And it was just a misdemeanor, and this was a young person, and I'm sure that if we went in and admitted, the court would have, what? Oh, put him on probation for 6 months, paid restitution, and blah, 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 blah. And the kid's like, I didn't do that. I was like, okay. So this was when I was in the public defender's office. We got the investigator. We interviewed people. We went out and looked around. We tried the case, and we won. They couldn't prove that my client did anything. I practiced for almost 6 years, and that's the case I remember best. Because the parents who didn't speak English, thanked me. The kid just looked like, oh my gosh, really? This just happened? Like we fought the system? Yeah, that's what happened. And that's the kind of thing that keeps us going. Even in the cases that maybe you're not the most headline grabbing or serious, and I hopefully that was a demo that, like, this is what we do. We don't just, get our clients services. That's not our job, right? And speaking of not our job, you know, um, has this ever happened to you, right? um, our observation is that, and everybody's heard me say this before, that we have 100 systems of justice in North Carolina, and everything runs differently in every courtroom. Specifically, like the roles of the prosecutor and juvenile justice, there are some places where the prosecutor is heavily involved. They work with the defenders. They know their cases. They're active. There's some jurisdictions where I remember one situation in a court that I observed some years ago where a prosecutor walked in with a pencil and said, "What are we doing today?" That's a true story. Like, there's no files. It's not even a pad. Whatever. And that's hard because you may be like, I don't even know what's going on here. But when you start filing motions, right, the DJJ doesn't respond to your motions like the prosecutor does. And now you're kind of forcing the prosecutor to do their job, like to respond to your concerns about your client's case. Same thing with juvenile justice. It's like, I need the records. Well, why do you need the records? Because I want to know what you know about my client so we can best address the case. Really? Yeah, that's my job. And your job is to give that to me. It's been the law for a long time. Even the judge, right? Oh, I'm saying something new. I'm sorry. Did I say something new about the judge? I mean, sometimes, granted, our judges are new and maybe they're not sure kind of what they're supposed to be doing, but their role hopefully is fairly clear. But it is our job sometimes to reinforce their role. And that's how kind of we explain it. Um, and this happens again, like we talked with the shackling a little bit, but this is the secure custody form. And those of you who do secure custody hearings, and times have changed a little bit because they're virtual or whatever, but in my day, this was the first hearing you had, right? Because the kids were in custody and their liberty was being removed, so they were the most serious cases to hear first. And on a Monday morning, you're showing up, and there's your row of kids, and uh, what do we do as defenders? Do we say, we can hear those cases later, Judge, or hey, my name is Mr. Zogry, and we'll get to you. Mm-mm. No, it's the first case that's heard on the Monday, kids in detention, and you are railing at the system. And you see, the judge doing this, the prosecutor's throwing up her arms, and everybody's all, worked up. And it's like, no, 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 no. And then you see the look on your client's face and the look on your client's parent or guardian's face. And suddenly they know the deal. They know why you're there. And so it just sort of smooths out the rest of the discussions, the conversations, the interactions with our client's parents. And again, I mean, somebody, tell me I'm wrong, but is there another job, at least in the legal system, where you have to explain to everybody around you what you do, why you do it, then you actually have to do the work. And then you have to continue to explain what you're doing and why you're doing it. Does this sound familiar to some of you? Like you're not actually doing your job. You're spending your time explaining why and how you're doing your job. Okay? Where is that? Is that that doesn't exist anywhere else, does it? I don't know. But it's frustrating and debilitating. And it would be great, you know, if we could get to a point where we don't have to do that, right? That we can just show up and do our job. That would be wonderful. And so everybody, I'm sure, has been in the position where, you know, um, you're you're at a party, you're talking to somebody on the street or whatever. Somebody asks you, "What do you do? What is your job?" Well, I'm a juvenile defender. What does that mean? Well, I represent youth accused of committing crimes. Really? Is that hard? What does that entail? And then you could go into a million explanations. You could, pull out this PowerPoint and say, well, but when I think about it, when I talk to others about it, this is what it comes down to. My job is to reduce my client's exposure to the system. That's my job. And you might be thinking to yourself, well, juvenile justice, da 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 da. I encourage everybody, if you haven't already, to read the biennial recidivism studies of the North Carolina Sentencing and Policy Advisory Commission. Yes, juvenile court does a lot better job of adult criminal court, but it's still a problem. And the one pervasive truth, not the one of the pervasive truths about the work we do is that the deeper you get into the system, the more likely you are going to stay in the system, the more likely you are going to stay in the system longer, and the more likely that you are going to get into trouble as an adult. So just sort of simple analysis is that what we do is we prevent your client's exposure to the system. That, in a nutshell, is what we do. All right. I had threatened this earlier. You all had time to think about it. I'm clicking. Here I go. Oh, here it is. All right. It's that time of the program where I want to hear some stories. I am going to stop sharing for a minute. I don't know if folks just want to jump in or you want to do the little hand raising thing. Is it this side or this side? I don't know. But let's just take a few minutes, folks. Tell me a story. Tell me where your expressed interest advocacy was a success, or when it was challenged and how you overcame that. Not in the chat. Okay. I want to hear it out loud. And it's like Hollywood Squares here. I'm not going to pick on anybody, but come on now. Let's somebody jump in, say something.
This was a couple of years back before I moved away. I recently relocated to the area, and I was, can everybody hear me okay?
Yep.
Okay, great. I was there was a transfer hearing, and I'm a very calm person, but this is the first time in my life I actually felt like getting up and putting my foot up somebody's behind. I felt like kicking the DA in the behind because we're about to get started with the transfer hearing. It's like, Your Honor, I don't feel like Attorney Dover has adequately expressed to her client the consequences of if this goes, if he's transferred to adult court. And I'm like, what? I mean, I was ticked off. I mean, I was really about to bawl. And I was like, Lord, help me. And my client looked at me, Miss Dover, what is he talking about? You've explained this to me about 4 or 5 times. What is he talking about? And I was like, I don't know, but I addressed the judge and let the judge know that, I had explained the process to my client, and I was wondering why the DA was so concerned about my relationship with the client. But in any event, we did have a good outcome. My client, my young person, was not transferred to adult court. He was remained in youth court. So that's an example where my role was checked, questioned, and basically, we had a good outcome. But I was just very surprised about that. And sometimes, we just have to realize that people will sometimes think that we don't know what we're doing, or they'll challenge it just to distract us. And I'm glad that, that wasn't a big distraction. Thank you.
Thanks, Charlotte. That was great. That's a great example. Okay, who's next? Nobody has a story? Come on now.
Hey there, Eric. How you doing?
Hey.
Good. This is Joel Edelman. And so we met about a month ago over at the murder CLE. And real quick about me, I'm, as I think we talked briefly, I'm in the public defender's office in Mecklenburg County. So we really don't do this work, but Kevin Tully, the public defender, is really trying to better coordinate the juvenile transfers, and he tasked me with being a part of that and taking most of the transfers. And so I am having some, and now I'm trying to get some training in juvenile, which I understand that jurisdiction is different, but juvenile, as well as working with the clientele. And that's the process I'm going through now. So just this morning, I was up, I have a juvenile murder client, and I was up at Cabarrus Regional Detention Center up by us, just north of us. And I'd spoken to my client a couple times. The case is new, and spoken to his father many times. And neither of them had mentioned to me that my client, when he was younger, was in YFS, and then I had been sending out subpoenas and getting for records, and of course keeping them apprised. But I don't know if when I told him what I was doing, if it just registered with them or not. So I brought up with my client just this morning. So listen, I don't want to get too personal with you, but certainly we need to, talk and be open with each other. But tell me a little bit about the circumstances of you being in YFS or in foster care. And I said neither you nor your father really have mentioned that to me, and he was really taken aback at me bringing it up. And sort of like what you said about how a client's reactions, they know when you're working for them, and they see it. And and he was like, man, dang, you're really doing your work. And it wasn't anything beyond a checklist that I have and things that I'm sure we all do. But when I knew things that neither he nor his father had mentioned to me. And by the way, this juvenile record was a 2011 record. His birthday's in 2006. So I was going back pretty far, but he was like, man. So I could see our trust relationship and his faith and trust really jump in that moment. And so I think that was sort of what you were looking for or asking about. But yeah, thanks a lot. But that actually just happened just a couple hours ago.
Thanks, Joel. And that's, I mean, obviously your client's potentially facing life without parole, and that's, the most severe punishment they can get. And I think certainly in that situation, that's got to be helpful to your client. So we really appreciate that. All right. Someone else, come on now, before I start picking on my office. Y'all don't want folks in my office to start talking. I know somebody's got a story.
Oh, so Miss Dover wasn't a plant. I was wondering if Miss Dover was a plant.
No, Miss Dover is just awesome. Come on, folks. Oh, Berger just sent a specific question about your role being challenged by a parent. I'm sure that's never happened to anybody on this in this training, right?
I can give you a quick one if you don't mind hearing from me twice.
Sure.
The parent complained that I had told or expressed that she did not care about her child. The parent really did not care about her child because we were in for a secure custody hearing and I was trying to get my client out. And the judge really didn't go for my argument. And the parent laughed. And I was like, this is your daughter. How are you laughing at your daughter? And she was a hot mess. She did not care about her child, but I never expressed that to the child. And the child basically, she knew, my client, she knew that I cared more about her situation than unfortunately the parent did. And so it was just basically, I think it was that parent's conscience because, that would be crazy to tell a child that the parent doesn't care, even if you do see it. So that's when I was challenged by the parent and never had a parent to laugh in court when the child was going to remain in secure custody. Thank you.
All right, let's hear from one more person and then we will move on.
I've got you. Can you hear me?
Yeah.
Hi, this is Reba, and I'm trying to get my camera working. Not certain if it is, but you guys don't really need to see me anyway. Happy Friday, everybody. That really touched a note of the parent not agreeing.
Uh-oh. I think we just lost Reba. Maybe she'll get back on.
I think we lost her. Yeah, her name dropped off.
Somebody else was about to speak, so go ahead. We'll get Reba next.
Sarita, was that you trying to? I think I saw your box light up. Did you have a story to share?
I was just going to say that I've gotten challenged by parents more so even when I come to interview my client or my client comes to speak with me and you have to tell them you're not my client and no, you can't come in at this point in time. Sometimes parents can be very belligerent about I'm speaking to their child and they think they need to be in there. And a lot of times the parent is the one who's the alleged victim or something of that nature. So it does come up quite a bit. And sometimes you just have to stand your ground with the parents.
Yep. You know, and you always got to remember, right, that they're going home with the parent, not you. Sometimes we have to remind ourselves of that and figure out, you know, the most effective way of, you know, trying to articulate what's going on. So when they go home, they talk about it, right? And they have a good discussion. Okay, I don't know if Reba's gotten back with us, but let's move on. I'm going to share my screen for the last couple slides. And so just wanted to make sure you all knew that this is not the first time we've talked about this. We have on our website, we have many resources on this. Sometimes we don't talk about it so, you know, up front because it's like I said, sort of an underpinning of what we do. But we have a lot more discussion about this, and you can find it on our website. There it is. And just sort of as to put a plug about our website, if you get on the Defenders portal, I hope everybody knows what our password is, and I don't know if I can do this while I'm doing my PowerPoint, but maybe somebody can stick it in from my office. Can somebody stick it in from the office? Somebody might be doing that. I don't know. Oh, thanks, Terry. Okay. So when you get to our website, go to the top left corner, Defender portal, check that out. I think most of these are not on there, but there are other resources. And let me go back here. So we've got a let me stop sharing just for a second. I see we've got another comment. Hold on. Oh, so hopefully everybody can see Victoria's comment. Wow. Okay, well, we'll think about that music one. Reba, did you come back and join us?
Guess what, Eric? I told my entire story and then realized I was only telling it to myself, but it was good for me to hear it again. I do apologize. Yeah, I usually use my desktop computer. I was trying to do it on the phone, a new phone. So I apologize, but it was really rather generic anyway about working with your client and their parent, and whether or not the parent agrees with your type of advocacy and understands. And in my opinion, you have to get the parent to understand that your role is whatever basically the child wants. And so sometimes it's hard to get a parent to understand that. So I apologize. Sorry about that. Didn't even realize that it had stopped.
No problem. We appreciate you sharing. Thanks, Reba.
Sure. Uh-huh.
All right, let's go back just a couple more quick slides. Whoops, just went too fast. We do have a link to evaluate the session. We're trying to figure out what it is you want us to talk about, how we could be doing it better. So there's the link. And thanks, Yolanda, for sharing it in chat. And then once again, just want to make sure everybody knows who we are and how to get in touch with us. Sadly, Latobi left a few weeks ago. We are still crying about it, but she is on to new and better things. But anyway, that is the presentation for the day. Unless somebody else wants to share something or has anything else to say, we'd be glad to hear it. But if not, you know, we can move on to our Friday and our weekend. And that's what I figured. All right. Well, everybody, thank you all for coming. I hope this was helpful. And we will be back next month. What is the topic for next month, Yolanda?
Placement issues.
Oh, all right. Well, we will look forward to that. And thanks everyone for attending, and we will see you next time.
Thank you.